to No Holding Back with me, Susan Estridge, the podcast where I bring you the biggest names from the worlds of media, politics, and law. We dive into unfiltered, unapologetic, and insightful conversations. I speak my mind, and I encourage my guests to do the same. No topic is off limits as we dive into the issues that shape our world. Today, I'm very glad to be joined by a very special guest. Glenn Kirschner is from the world of prosecution, from the world of law. He spent 30 years as a federal prosecutor with experience in the Department of Justice, where he specialized in prosecuting some of the most complex cases, including homicide and public corruption. He served as an assistant U.S. attorney in Washington, D.C., as chief of the homicide section, where he led a team of prosecutors in high-stakes cases that often made national headlines. Glenn's expertise doesn't end in the courtroom. When he retired from the Justice Department, he became a television star and a media star. He's a regular legal analyst on MSNBC and NBC News. He hosts a very successful YouTube show entitled Justice Matters with nearly 1 million subscribers. His insights have made him a respected voice on issues of justice, accountability, and the rule of law, topics that are more relevant than ever before as we head into the election. Glenn, welcome to the show, and thank you again.
Oh, thank you, Susan. I'm so happy to be joining you.
Well, we're delighted to have you, and it's very timely because as we're recording this, Jack Smith has just filed a new indictment in one of the Trump cases, and I'd love to run through Trump's legal problems with you because you know them and understand them better than almost anybody. What's going on with this new indictment?
Yeah, so the re-indictment, I think, took us all by surprise. This is what's called a superseding indictment, fancy word for a second or subsequent indictment that replaces the first indictment. So, what I was looking for in the wake of the Supreme Court's horrific, in my opinion, absolute immunity ruling. I have often quoted one of the preeminent constitutional scholars, Professor Akil Reed Amar, who wrote in The Atlantic that what they did in a very real sense was declare portions of the Constitution unconstitutional. And we are now adrift as far as the Supreme Court goes. They can't be trusted to stick with the text of the Constitution. Indeed, they have contradicted it. So we have some cleanup to do in the years ahead of us.
That's an understatement, Glenn. Yeah. Akil is an old friend of mine, Yale law professor, really smart guy. And I hadn't read that article, but that's right on point.
Yeah.
How do you get rid of the Constitution, Glenn, before you go on? In what way do you think they got rid of the Constitution?
So in a couple of ways. There are two parts of the Constitution that I believe directly contradict this absolute presidential immunity nonsense that the Supreme Court just conjured up out of whole cloth. First of all, a president has the constitutional obligation to take care that the laws of the nation be faithfully executed. That is the opposite of giving him absolute carte blanche to violate all of our nation's laws with impunity. The second provision is the impeachment judgment clause, which says a president, anybody, it doesn't specify president, but we know a president can be impeached. A president can be impeached by the House of Representatives and convicted in a Senate trial on those articles of impeachment, and he still is subject to indictment, trial, conviction, and punishment, indeed, for the exact same conduct that got him impeached by the House and convicted in the Senate. They have ruled the Constitution unconstitutional. And this opinion, Susan, I believe one day will go the way of Dred Scott, Plessy versus Ferguson, and Korematsu. It must.
I agree with you on that completely. I was horrified, and it really, there have been some opinions that I strongly disagree with. Obviously, Dobbs is one of them, but this one came out of left field for me. I didn't think they'd go this far, quite frankly. I always thought that, the Chief Justice was a man who cared about consensus, who cared about the country supporting the Supreme Court, who cared about the public judgment of the Supreme Court. And this one threw it all out the window, didn't it?
I agree. And I thought Chief Justice Roberts cared about the legitimacy and the
Yep.
perceived legitimacy of the institution, and he threw that out the window as well.
He threw it out the window. Wow. I'm just curious. This opinion is so important. I'm just curious to get your views. Why do you think he did that? Just to get his
You know,
majority?
I think it is, as I believe Justice Gorsuch said in the argument, oh, we have to write a rule for the ages. And, maybe they are unduly enamored of an all-powerful chief executive, and they threw out the baby with the bathwater. I am not prepared to say this was a Trump-specific Supreme Court ruling, though obviously Donald Trump is the one and only president or former president who will benefit from it. But what they have done is given tomorrow's aspiring dictator the exact blueprint to end American democracy with impunity. Couldn't even be criminally, held accountable for it. So if I had hair, I would be pulling it out. And this is something that we have to tackle moving forward.
Yeah, I don't know how we tackle it. I mean, we tackle it by winning this election and getting some more justices on the Supreme Court who will not stand for this kind of wholesale abdication of the Supreme Court's responsibility. But in the meantime, you've got Jack Smith sitting there, and he's got this case against Donald Trump. What happens to it? Does this indictment work to get around the opinion?
Yeah, this superseding indictment was a stroke of genius for two reasons, in my opinion. I have the utmost respect for Jack Smith. Some of my former federal homicide prosecutors have circled through his team and are on his team presently. I have the utmost confidence that the American people are being extraordinarily well represented by Jack Smith's team of prosecutors. What he decided to do, rather than sit back and litigate each act that was in the first indictment, those 4 felony charges that Donald Trump was indicted on, rather than litigating each act in front of Judge Tanya Chutkan, who is presiding over the DC January 6th case, to determine, is it an official act? Is it not an official act? Does it enjoy presidential immunity under this new harebrained Supreme Court precedent? Does it not enjoy presidential immunity? He went proactive. He said, what I'm going to do is I'm going to retool and pull out of the original indictment everything that I believe might enjoy presidential immunity in the wake of the Supreme Court's ruling. And I was so heartened, Susan, to see after he did that, and he pared it down from a 45-page 4-count indictment to a 36-page 4-count indictment. I was so heartened to see that he believed he still had enough admissible evidence that did not enjoy presidential immunity, that all 4 felony charges remain. And I was so thrilled to see that. Now he'll take this pared down indictment and he will litigate the question of whether he was right. And if Judge Chutkan agrees with him, those 4 counts will remain. Then, of course, this case will meander its way back up to the Supreme Court. But the other thing that I want to mention, and I was on Morning Joe this morning, and part of the reason I was a couple of minutes late, I apologize. I didn't get to talk about this, but I think it's really important to understand just how adept Jack Smith and his team of prosecutors are. Probably the easiest job in Washington, D.C. is being Jack Smith's press secretary, his spokesperson. Why? Because Jack Smith doesn't speak publicly. However, yesterday, when this new superseding indictment was returned, Jack Smith's spokesperson issued a 2-sentence press release. The first sentence, as expected, said that a superseding indictment with the same 4 felony counts has been returned by the grand jury. But more importantly, the second sentence said that the evidence was presented to a new grand jury that had not previously heard evidence in this case. The reason that's so important is because Donald Trump's lawyers would have screamed bloody murder if Jack Smith stuck with the first indictment. They would have said, wait a minute, that indictment is the product of privileged information, so the entire thing is tainted. Jack Smith cut that argument off at the pass. And I'll tell your viewers, Susan, I've litigated these issues where information goes before the grand jury that should not have. Irrelevant evidence can go before the grand jury as long as it's reasonably calculated to lead to relevant evidence. Evidence that may have been seized in violation of the target or the defendant's constitutional rights can be presented in the grand jury, because the grand jury is not the time to litigate a motion to suppress that kind of evidence. Although I'll add, DOJ has a policy of prosecutors not introducing something that they believe was evidence taken in contravention of a defendant's constitutional rights. However, there are some things that go before the grand jury that can taint the grand jury investigation and render an indictment invalid, like if prosecutors put privileged information before the grand jury, whether it's attorney-client privilege, whether it is spousal privilege, doctor-patient privilege, or executive privilege. That can taint a grand jury's investigation. Then we have to litigate it. Or if there is perjured testimony that is incriminating, that can invalidate a grand jury indictment. And then I've litigated these issues. You have to have a motions hearing before the trial court judge extracting the perjured, incriminating testimony, and the judge has to decide whether the balance of the evidence supports the grand jury indictment. I didn't mean to turn this into a criminal law 101
this
class,
is very
but
helpful.
all of this, I think, just goes to show Jack Smith is 3 steps ahead of where many other lawyers might be at this time.
If he's 3 steps ahead, Glenn, is this indictment going to go to trial, or you mentioned briefly that it'll go back to the Supreme Court? How long is it going to take for Donald Trump to face justice, if at all?
That's up to the Supreme Court, and we have seen the Supreme Court is amenable to extended delays when extended delays were unnecessary and uncalled for. Jack Smith tried to bubble up this issue instantly the first go round by urging the Supreme Court to just let the case leapfrog the District of Columbia Court of Appeals, the Federal Circuit Court of Appeals for DC. And the Supreme Court said nope. And then they wasted another 6 or 8 months when they didn't have to. So what will happen now, Judge Chutkan will have the hearing, will decide, will rule what is privileged and what's not, what counts survive and what evidence survives the Supreme Court ruling. That will go to the DC Federal Circuit Court of Appeals. They likely will affirm Judge Chutkan, as they have done in the past on her consequential rulings. Then it's up to the Supreme Court again. They will delay this and do as much of a favor, at least on the timing front, for Donald Trump as they want to do.
So is there any chance at all that any of this comes to fruition before the election?
The thing we may see before the election is some of the hearings, whether evidentiary hearings or not, they might be done by proffer, just a fancy word for we're not going to put on witnesses. We're just going to tell the court the evidence that we have, and then the parties are going to argue whether that evidence involves an official act, an unofficial act, whether it enjoys immunity or not. So it may be by proffer, or they may start putting witnesses on. And let's remember, Donald Trump was convicted on an almost exclusively Republican chorus of voices testifying before the grand jury in Washington, D.C. about all things January 6th. So the nature of the hearing that Judge Chutkan will conduct, there's supposed to be a filing this Friday, and the parties were supposed to make their recommendations on what that hearing will look like. And then I believe we're in court on September 5th. I cover all of the cases in person here in Washington, D.C. And if those dates hold, I don't know that they will given the superseding indictment, but if those dates hold by September 5th, we should know more about the nature and the timing of the hearing that Judge Chutkan intends to hold.
And that hearing could be an eye-opener, couldn't it? I mean, couldn't that hearing hurt Donald Trump?
It certainly could, because listen, we know perhaps 1/10 of what Jack Smith knows about the incriminating evidence that was developed before the grand jury supporting both the first indictment and the superseding indictment. So it could certainly be enlightening. But, now let me talk about the flip side of the coin. As a prosecutor, I always wanted to hold my cards very close to the vest before trial proper. I had to litigate some things in pretrial hearings, but boy, was I stingy. I only introduced as much evidence as I thought I needed to win the legal issue we were litigating. I didn't want to give the defense a preview of some of my strongest evidence. They will be, all the more prepared to meet the force of it at trial. So Jack Smith has some interesting tactical choices to make about how much he wants to present when it's not yet a trial proper.
So if he doesn't present evidence at trial, in the hearing that he's going to use at trial, Donald Trump, in some sense, gets a bye on this, doesn't he? I mean, the Supreme Court gave him a bye on what should have been, in my mind at least, the lead case against him of all these indictments.
He will get another pass because delay is what he covets, right? And he is sort of the king of delay. I don't like to say he's the king of anything. Of course, he's promised to be a day one dictator, so he kind of wants to be the king of the United States. But he will get something of a pass if they do it by proffer. In other words, they don't call witnesses to testify live, direct examination, cross-examination. That would be very revealing and informative. But what Judge Chutkan is still going to have to do is look at this 36-page superseding indictment, and they're going to have to argue over every single act included in it and every single piece of evidence over and above what's included in the indictment regarding anything Donald Trump did, because they're going to have to decide whether each piece of evidence is official or unofficial, enjoys immunity or doesn't enjoy immunity. So even if it's by proffer, I still think we could learn a whole heck of a lot, and it's all going to be bad for Donald Trump.
This stuff about the pressure he put on Vice President Pence, isn't that, I mean, that's not an official act, is it?
Well, in the Supreme Court opinion, they hinted that it is, that it's like
I know, I saw that, and that was appalling.
Right, for a president to speak with a vice president. But what Jack Smith has said is no. First of all, he wasn't acting as a president. This is not official. He was acting as a candidate. Second, the person he was communicating with was Mike Pence. And in most settings, you're communicating with Mike Pence as president to vice president, but not when Mike Pence is sitting as the de facto president of the Senate. That's a whole different responsibility. And he's not acting as a member of the executive branch when he does it. So that's another distinction Jack Smith has drawn. And I have to believe Judge Tanya Chutkan understands and appreciates this. I will add as a footnote, I used to try murder cases against Tanya Chutkan when she was a public defender in the courts of Washington, D.C., and I was a federal homicide prosecutor. I have kept up with her career and with her ever since. She's the real deal. I've said it many times. She don't play, and she's going to get this right. I think she's going to be forward-leaning in her rulings, but not violate the letter of the Supreme Court absolute immunity ruling. And I have the utmost confidence, not only in Jack Smith and his team, but in Tanya Chutkan as well.
That's great to hear. Let me ask you one last question about that case, and then we'll move to some of the others. Is there any chance at all that if the Supreme Court doesn't take the case, there could be a trial before the election?
I think there's zero chance, and I wish that weren't the case. I like to always find that little bit of silver lining behind the big orange dark cloud that we live with.
Yeah.
I don't think there's any chance. They still need to resolve legal issues. They would need to put jury selection processes in place, including sending out jury summonses to it's a long, involved run up to trial. So I don't think there's any chance we see anything other than that kind of hearing designed to figure out what survives in the indictment and what might not survive.
And then what happens? He wins the election, he pardons himself. He doesn't win the election. Does this prosecution go forward?
Yeah, he doesn't win the election. He spends the rest of his life in courtrooms and, if convicted, perhaps in prison. If he wins the election, he doesn't even have to worry so much about a pardon. He appoints, I don't know, Stephen Miller. I don't know who he's going to appoint as attorney general. I don't know how far you can go below the Bill Barrs of the world, but he appoints a lackey, a flunky, a lapdog, and he orders that person to dismiss all federal cases against him. He orders that person to withdraw the appeal that has been lodged now with the 11th Circuit Court of Appeals in the classified documents obstruction of justice espionage case. And I can promise you, Susan, he will find every way he can, lawful and unlawful, to do away with the state cases against him, probably using some trumped up version of the supremacy clause, or just ordering the military to do his bidding, which he had said he doesn't care about posse comitatus, where law enforcement is not permitted to, military forces are not permitted to engage in civilian law enforcement. He's already hinted that he'll do away with that. He will go to trial in 0 cases if he is elected president, and I do not believe he will be.
Well, I love hearing you say that. Let's get back to that in a minute. So the Florida case, what's with Eileen Cannon? I mean, you follow these judges pretty closely. What is with this woman?
Yeah. I can't look into her heart or her mind, but what I can do is look into this big, ugly blue book of federal laws, the United States Code. I never leave home without it, and read the federal law regarding when a judge must disqualify himself or herself from a case. And it's 28 United States Code 455 for anybody scoring at home. And it says that any federal judge, any Supreme Court justice, if we want to talk about Alito and Thomas, any federal judge, Supreme Court justice, or magistrate judge, a lower level federal court judge, whose impartiality might reasonably be questioned, shall disqualify themselves, remove themselves from the case. I have always maintained that is not the word, that is not proof beyond a reasonable doubt. Might reasonably, not subjective, but objective, be questioned. She jumped that shark a year ago, right? She has twice been reversed for abusing her discretion, doing a favor for Donald Trump that the law did not allow. Twice by the 11th Circuit.
What were those favors, Glenn?
Those favors were when she was interfering with the Department of, interfering is the word the 11th Circuit used, with the Department of Justice investigation into the classified documents, our national secrets that Donald Trump was illegally retaining and obstructing justice by refusing to give back pursuant to a grand jury subpoena. She told the Department of Justice, you may not investigate Donald Trump using those seized documents. And there were two separate issues that bubbled up to the 11th Circuit. Both times they ruled she abused her judicial discretion, and no judge has a right to, quote, interfere in a Department of Justice investigation. Susan, we're up on the 11th Circuit again now on this special counsel ain't a thing motion.
What is this
it's
all
insane.
About?
It's insane. Every judge, trial court, appellate court, and the Supreme Court in 1974 concluded special counsel, independent counsel, special prosecutor is a thing, is lawful. And indeed, Richard Nixon had to comply with a subpoena from the special prosecutor. Eileen Cannon said the Supreme Court didn't know what it was talking about, nor did any of the other trial court or appellate court judges know what they were talking about. I'm saying special counsel ain't a thing. That, I think, is an abuse of her judicial discretion. And if the third time is not a charm, being reversed by the 11th Circuit, not a charm to finally have Jack Smith file a motion to recuse, a motion to remove her from presiding over Donald Trump's case, I don't know what is. Maybe the 11th Circuit, if they reverse her a third time in a case involving Donald Trump, sua sponte on their own says, Aileen, you're out. I've seen circuit courts do that. You're out. We need a fair, impartial, and independent judge to preside over this case. I hope that's the way it goes down in Florida, actually Georgia, the 11th Circuit Court of Appeals, which has authority over the court that Eileen Cannon presides in.
When can we expect a decision from the 11th Circuit?
Great question. We had Jack Smith file his brief, 88 pages, brilliantly done, not surprising. He's got remarkable appellate and constitutional lawyers on his team. That was earlier this week. So now Trump's lawyers will have about 30 days to file their opposition. Jack Smith will have, I think, a week or two to file his reply to their opposition. It will be set for oral argument, probably in fairly short order. And then the 11th Circuit could resolve it in a day, a week, a month. We just don't know. Again, no chance that we're going to get, I don't think, an opinion out of the 11th Circuit on the special counsel thing before the election. But I do believe to my core, and I was an appellate guy in both the Army courts before I became a federal prosecutor with the Department of Justice and the DC appeals courts, both local and federal. I have to believe they will reverse Judge Aileen Cannon,
They
reinstitute the prosecution, and Jack Smith will continue to be the point prosecutor on it.
It's really stunning to me, Glenn. I don't know if it's stunning to you, how successful Donald Trump has been in this strategy of delay. I mean, he's gotten delays that I never expected, and that the Supreme Court went along with this, that Judge Cannon went along with this. It's just unbelievable to me. The system has not worked at all.
You know, we have some judges who are not honest brokers of the law, and it pains me to say that because I have such respect for the federal judiciary, not to mention the local judiciary and the state courts, where really 99% of the hard work of criminal justice in our nation gets done. But when you have the Thomases and the Alitos, and to a lesser extent, some of the others, but I think those are the two major offenders in violating our federal public financial disclosure laws that I labored under for 30 years, having to fill out those forms every year. It was the bane of my existence, but I did it. And I tell you, I triple checked to make sure I didn't put a decimal point in the wrong place because I didn't want to mislead or omit anything. And then you have Judge Aileen Cannon. I actually think it only makes sense to set a rule or maybe a law moving forward that if the president of the United States is criminally indicted in federal court, his case should not be presided over by a judge that owes her or his entire life tenure on the federal bench to the defendant. If there was that relationship in a non-governmental setting, like a CEO was being tried for something and that CEO had previously done something extraordinary for this federal judge before they took the bench, that would be a conflict all day long, at least an appearance, if not an actual conflict. So Susan, we have so many problems to fix moving forward. And if the election shakes out the way it is in a pro-democracy way, we will perhaps have the tools to tackle some of these problems.
Perhaps. What do you think of the Georgia case?
You know, that is on a very long, slow track. Now, it's not just this case. There are cases down in Georgia, RICO cases, that have lingered for years. And every jurisdiction handles its own criminal justice system differently. So right now, we are waiting for oral arguments before the Georgia Court of Appeals on whether Judge McAfee got his ruling right when he said District Attorney Fani Willis is not disqualified, and gave them some opportunities to clean stuff up on the appearance front. But now that is being appealed and it is set well off into the future. I want to say February, though I don't keep all the dates in my head. So that's on a very slow track. But Fani Willis is also, in my estimation, the real deal. I also think Judge McAfee has done a pretty good job managing an extraordinarily challenging criminal RICO case. I've tried RICO cases in DC. They're not easy. They are big and unwieldy at times. He's done a good job. And I think as long as it takes for Fani Willis to obtain justice for the voters of Georgia, she's going to do it. And she's going to do it aggressively and unflinchingly and tirelessly. Just as I believe, Susan, 2, 3, 4 years from now, we will still be talking about Jack Smith's prosecutions of the upper echelon of the insurrection, what I call the suits of the insurrection, not the boots of the insurrection, the hierarchy, the command structure. Jack Smith will be going after those people for years until the last one has been held to account. I believe that to my core.
I love hearing you say that. Let me ask you about the last one, the New York case, which Donald Trump has been haranguing about, but where he was convicted on 34 counts. At first, I thought it was the weakest case of the 4, but as the case unfolded, I really came to the conclusion that it was a case about election interference and that it was a very serious case and that he deserved to be convicted. What's your take?
I am so with you. That was chronologically Donald Trump's first foray into committing crimes to interfere in an American election, happened to be a presidential election in 2016. Drives me to distraction when I hear the media forever calling it a hush money case. It's an election interference case. More precisely, it is a falsifying business records case to cover up hush money payments motivated by a desire to cheat in an American election. It's an election interference case, just as the Georgia cases, just as the DC cases, and of course, the case down in Florida is him stealing our nation's secrets and refusing to give them back. Maybe not an election interference case, but extremely damaging to our national security. So I think in New York, the question that we're sort of on the edge of our seat waiting for an answer to is, will Judge Merchan, one, rule that the prosecution is sound even in the wake of the presidential immunity ruling? I believe he will, because the mountain of evidence there, the lion's share of the evidence, he was committing crimes before he was president. Things he did after he was president, like writing reimbursement checks to his lawyer and fixer Michael Cohen, those can't possibly be deemed presidential acts. You're repaying, the dirty money that you had your fixer pay to hush up a porn star to cheat in an election. Can't be an official presidential act in my book. So I think Judge Merchan will rule on the 16th, as he promised, that this case can proceed to sentencing. But in the 48 hours between the ruling on the 16th and the sentencing date, which is still set for the 18th, it remains, of September, Donald Trump has indicated he will beat feet to appeals courts, both state and federal. We don't know if he can jump into the federal system that easily or quickly. I don't believe he can.
That.
Yeah, you shouldn't be able to. But then Judge Merchan may say, listen, I'm not going to proceed to sentencing on the 18th with all of these appeals lodged. So maybe he pushes the sentencing. I hope he doesn't. I hope he sentences him. He must sentence him to a period of incarceration, because if you don't, then all of this has been for naught. You are sending the signal to all crooked politicians out there who maybe would have been deterred to commit crimes to try to steal American elections. He would be sending the signal that you can do it, you can benefit from it in the election, you can be indicted, go to trial, be convicted, and be sentenced, and receive no punishment. If you adjudge home detention for Donald Trump, what does he do? He goes to Mar-a-Lago and he binge watches Netflix and orders DoorDash. That's not punishment for those crimes designed to steal a presidential election. I believe Judge Merchan appreciates the general deterrence importance of a sentencing in a case like this. I don't believe he'll order this sentence executed. In other words, if he imposes a sentence of incarceration, he'll probably stay execution, not make it start until after the appeal has run. But let's get that sentence of incarceration hanging over his head, and as a signal to every other aspiring crooked politician or day one dictator that if you do what Donald Trump did, this is what is awaiting you. We have to do that.
Do you think that's what's going to happen? I mean, I hear your impassioned plea, and I agree with you. But I don't know this judge, and I haven't followed it as closely as you have. Is he going to have the guts to sentence the Republican nominee a week after the debate in the heat of a political campaign to prison?
That's a great question. And here is what I say when I always want to hedge my bets. I say 51% of me says that's what will happen. 1,000% of me says that's what should happen. I think it needs to happen. Will it happen? I'll stick with that 51% prediction, because then when I'm wrong, I can say, well, 49% of me was right.
We've got a president who's already facing 34 counts. Is he going to get elected, Glenn? You made hints already about how democracy should work. What do you think is going to happen in this election?
I don't think Donald Trump has attracted one new voter to his cause since January 6th, but I do know people have peeled away from him. People who voted for him previously, I've spoken with, and they are not going to vote for him this time. They may or may not vote for Kamala Harris, but they're not going to vote for Donald Trump. Maybe there are some who said, you know what? Donald Trump was an open question in my mind, but after he did what he did on January 6th and everything that he's done since then, I'm liking him more and more. So I'm going to first vote for him in the 2024 election. I think it's going to be a landslide. I'm not complacent. I'm not counting our chickens. I think it's going to be a really lopsided affair. I'm actually less concerned with the vote than I am with the voter suppression, and than I am with the bogus legal challenges, than I am with poll watchers intimidating voters when they try to cast their ballots. Those things have me very concerned. But the good news is Joe Biden has the reins of government. And what happened on January 6, 2021 will not happen again, because just as Donald Trump set the Capitol up for failure is my sincere belief. I'm intimately familiar with all of the countless law enforcement agencies in Washington, D.C., because there are countless law enforcement agencies, but one prosecutor's office, my former office where I worked for decades. He allowed the Capitol on January 6th, everybody knowing an attack was imminent, to go largely unprotected. My poor friends, the Capitol Police, they were so outnumbered and outmatched. And my friends from the Metropolitan Police Department, who responded to their emergency calls and were damn near killed, like the Mike Fanones of the world, who I handled murder cases with decades ago. Donald Trump set the Capitol up to be taken that day. That is my firm belief. That will not happen again. I hope there aren't pockets of violence that erupt when Donald Trump loses, and I believe he will. But if they do, we're going to have the forces at the government's control to put them down. You know, I'm an old Army guy, and sometimes violence occurs. It's a reality of not only American life, but life all around the globe. But at least we will have the tools and the forces necessary to deal with that. So yes, I have lots of concerns. I would even call some of them fears for American democracy and for this election cycle. I think we're going to come out of it in a far better place. And I think Donald Trump will largely be in our rearview mirror politically, and then legally, we're going to be watching every minute of every trial, and we're going to be there for all of it.
You're such a fabulous guest. I hope you'll come back as these cases go forward and share your insights, because you really are just a fabulous, fabulous commentator on what's going on. And
Well,
I would encourage everybody to watch Justice Matters, your YouTube show. I can see now why you have 1 million followers, and it's been just a pleasure having you on the show.
well, thank you so much for inviting me, Susan. I really appreciate it.
You've been listening to No Holding Back with me, Susan Estrich. I want to take this moment to thank again Glenn Kirschner for a fabulous conversation. If you enjoyed the show, make sure to subscribe so you never miss an episode. You can listen to us on Apple Podcasts, Spotify, or wherever you get your podcasts. You can also watch every episode on our YouTube channel. Please leave a rating and review on your chosen platform. It helps us reach more listeners and keep the conversation going. Follow us on X at No Holding Back FM. And for my weekly column, visit our website, estrichgolden.com. Thank you so much for listening, and I'll see you next time on No Holding Back.